outlying districts because during the campaign he was outlying in all of them. Annette is not very bright. She thinks that Gatorade is welfare for crocodiles. And how do you make the judge laugh on Monday? Do you know? You tell him a joke on Friday. And did you hear about the boy who took a group of 19 friends to the movies because the sign outside said 18 and under, not admitted? And another boy saved up $45 for a rock concert because he read that the tickets were $20 in advance and $23 at the door. Now, it's sunshine. There is sunshine for the first time since Saturday, maybe? Sunday, Monday, Tuesday. No sunshine. Oh, thank you, Lord. Thank you, God, for this great universe. It's an interesting universe. It's an interesting life. I think now I'm going to have to start reading you these legal papers because you must know what's going on in your courts. And you must know that God forbid anything bad happen to you and you go to a court for justice, you are not going to get it. You want to know why? Your courts have been stolen. These are your courts, the people's courts. They have been stolen. They have been stolen by a bunch of gangsters and a bunch of civil RICO racketeers. So let me read the papers to you. It's going to take a long time and it's hard work, but the information has to go to you. This is the Raji paper, 90 pages. Where is the court? The Eastern District of New York, Brooklyn, Federal Court, abuse thereof. This is the lawsuit. United States District Court, Eastern District of New York. Shareholder Glendora, plaintiff. This lawsuit was filed in 1998 in the so-called Supreme Court, State of New York, County of Nassau. It has many defendants. I hate this wire. No matter what you do, it's wrong. So we have a clean wire. An impedimenta. An impedimentum. An impediment. Shareholder Glendora plaintiff versus Robert S. Lemley, Executive Director of Cablevision, CSC Holdings, that's Cablevision Systems Corporation Holdings, Incorporated, Cablevision Systems Corporation, Its chairman, Charles F. Dolan. Its chief executive officer, James L. Dolan. Its board of directors, its officers, its management, David Deitch, Charles A. Former, Deborah, Kathleen, and Mary Ann Dolan, Lemley secretary, and security, Robert M. Callaghy, okay, the Cablevision Political Action Committee, and sadly Stevens, Burke, and Burke, who are the Cablevision, they are the Liar for Hire group. And John C. Malone, the former chief executive officer of TCI, the estate of Bob Magnus, the former chairman of TCI, TCI itself, Telecommunications Incorporated, Richard Wadman, its manager in Westchester, Central Westchester, John Wicker, a temporary manager, somebody who's hauled in, Ben Wiles, a liar for hire for TCI up in Albany, who got fired, and Joshua N. Koenig and Paul Rapp, another liar for hire group, Baker and Botts, which I call Baker and Botch, a law firm in Manhattan, another liar for hire, Bertram Perkle, the poorest excuse for a lawyer that I've ever seen, Jerome Kern, doesn't write music, he just writes his name on TCI checks. Hello, Rusty Dog. You Rusty Dog. Glenny glad to see the Rusty Dog. And Salisbury, a flunky working for Baker and Botch. And William C. Connor, a United States District Judge who thinks more of himself than he does of his country. Jed S. Rakoff, another United States District Judge, the same. Everything's for himself and nothing's for America. Mark D. Fox, the well-known cheater, magistrate so-called, teacher's helper in the White Plains Federal Court, who's been sued extensively. Barbara S. Jones, another cheater, United States District Judge, another soul seller. Amalia Curse, a circuit judge, Second Circuit. Jose Cabranes, another. Denny Chin, a district judge who was called to sit on the circuit, Second Circuit because they were short of circuit judges, a fill-in. Charles L. Bryant, a well-known and well-established cheater, federal judge in White Plains. Thomas A. Tormey, a cheater, former law clerk of Charles L. Bryant, a fugitive. U.S. West, a company no longer exists. They owned a telephone when the bell was broken up into baby bells. They had the one out around Colorado and Montana. Media One, the old Continental Cable TV owned by Hofstadter, Media One. It was gobbled up by U.S. West. Richard McCormick, the former CEO of U.S. West, who has lost his job. And Charles Lillis, the former manager of the cable TV operations of U.S. West, who is also put out of a job. Thomas E. Walsh II, a liar for hire in Congers, New York, Rockland County, who lied all the way through Glendora versus John C. Malone, Glendora versus TCI. It was Glendora versus Continental Cable TV, Amos B. Hofstadter, and Thomas C. E. Walsh lied his way all the way through that, along with a magistrate named Lisa Margaret Smith, and along with a federal judge named Barrington D. Parker. Joan M. Azrak, a lying magistrate in the Eastern District of New York. Robert M. Levy, another. Edgardo Ramos, a cheater, assistant U.S. attorney. There are no other kinds in the Eastern District. And William Brenner and Philip Bigger, cheaters who ran the so-called pretrial services in the Eastern District of New York. Those are the defendants. Case number in the Nassau Supreme Court is 98-030-337. The case was robbed from the state court and put into the federal court, a very crooked thing that federal people do. And it makes Rusty sick, doesn't it, Rusty? It's just disgusting. And the case number in federal court, so-called, is 99 Civ 922. Jury trial demanded. And the name of this paper is Shareholder Glendora Answer to Raji Order of February 6, 2001. There's nothing so simple the courts can't make it difficult. You should be able to go to court and get justice in one day, and it shouldn't cost anything. You should be able to go to court and get justice in one day, and it shouldn't cost anything. But our courts have been turned into a money-making machine by dirty judges, by gangsters in black robes. Part A. Well, first of all, I have to read you Raji's order. Who is Raji? Rena Raji, a United States District Judge, Eastern District of New York. The evil Eastern District of New York. We are looking for Raji's order of one page. United States District Court, Eastern District of New York, Glendora, plaintiff, against Robert S. Lemley et al., defendant, should be defendant. United States District Court, Eastern District of New York, Glendora, plaintiff, against Robert S. Lemley et al., defendant, should be defendants. The magistrate on this case is RLM, and this is an order, and the appearances are Glendora, Chat with Glendora, Box 416, White Plains, New York, 10602, plaintiff pro se. The Honorable Loretta E. Lynch, United States Attorney for the Eastern District of New York, 1 Pierpont Plaza, Brooklyn, New York, by Mark Goldberger, Assistant United States Attorney, Attorney for Defendants. This caption is wrong. It's shareholder Glendora plaintiff. And Raji, District Judge, the court noting there is a motion by the defendants to dismiss this action which was pending from before this case was reassigned from Judge Nickerson to Judge Raji. Very poor English. Hereby orders plaintiff Glendora to file any response to this motion no later than March 9th, 2001. Failure to do so may result in the dismissal of this case. The defendant shall file any reply on or before March 23rd, 2001. The clerk of the court is instructed to docket this motion as having been served and filed on the date of this order. So ordered, dated Brooklyn, New York, February 6, 2001, Reena Raji, and I will show United States District Judge, and I will show you her signature. Pretty good. Not too bad. It's legible. But the Mark Goldberger is wrong. Okay, now we'll start this 90-page paper. I've got to go to another channel. This is going to take several programs. Okay, Glendora is Part A. What defendants moved to dismiss? Do you know which defendants moved to dismiss of that long list of defendants I read you just now? What are their names? Whom does Mark Goldberger represent? Court's appearance listing for Glendora is perfect. Thank you. Court's appearance for Mark Goldberger is imperfect. No motion to dismiss is properly before the court. Plaintiff has no motion to dismiss until the alleged motion to dismiss is properly served on plaintiff at the name and address given in the court's appearances. Alleged motion to dismiss is not properly before the court. Glendora cannot oppose a motion to dismiss that she does not have. Part B. Defendants are hopelessly in default. Glendora's motion for judgment by default is before the court. This motion cannot be ignored. Defendants have never defended themselves. Defendants are in double default, and this is not a tennis game. Default judgment should have been granted by the Supreme Court, County of Nassau, State of New York, by John P. Dunne, D-U-N-E. This is a done deal and not the right meaning of done. Now, said motion must be granted by this court pursuant to Federal Rules of Civil Procedure, Rule 55. C. The case was improperly removed pursuant to 28 U.S. Code, Section 1441 to Section 1449. 1. Section 1441, Glendora versus Lemley, could not have been properly filed in the Eastern District of New York. It would be foolish to file a Glendora case in the Eastern District of New York. The record shows irrefutably that Glendora cannot get justice in the Eastern District of New York, so the case could not be filed in the Eastern District of New York. Common sense. 2, all defendants must join in the removal, and this did not happen. 3, removing defendants have the burden of proving removal is proper. They have not. Page 6. A removal, like a transfer, has to be in the interest of justice. 28 U.S. Code Section 1404. State court did not lack subject matter jurisdiction. The state court could have handled this case against the Cablevision defendants, saying that the Cablevision defendants, and as a subscriber you know this fully well, is a civil RICO. Cablevision is a racketeer. They use intimidation. They use extortion. They are money motivated. They are an enterprise. They fit every description of a civil RICO. The complaint on that was very well pleaded. It was read to you 2 years ago. All of Glendora's claims are covered by the Constitution, State of New York, Bill of Rights, Article 1. So the case did not have to be removed from state court to federal court. You want to know what's going on when they do this? They remove cases when it's a federal defendant. When you've sued somebody in the federal government in state court, the crooked federal court pulls the case out of state court so they can bring the federal defendant under their wing and get him off the hook. You think you have any courts left? You do not. 7, Glendora has never received a notice of removal. This makes the removal fatally defective. Removal violates Glendora's 11th Amendment right, U.S. Constitution. There is no proof of service that all defendants were notified. Plaintiff was not notified. New York State sovereign immunity prevents removal. Page 7. The Raji court should abstain. Abstention is the right thing to do at this point. The case should be remanded by abstention. Defendants and court have not arranged for the record to be moved from state court to the Raji court. No notice of same has been provided. 28 U.S. Code, Section 1449. State court records supplied where a party is entitled to copies of the records and proceedings in any suit or prosecution in a state court to be used in any district court of the United States, and the clerk of such state court, upon demand and the payment or tender of the legal fees, fails to deliver certified copies, the district court may, on affidavit reciting such facts, direct such record to be supplied by affidavit or otherwise. The federal court has failed to do this. Removal is a nullity. Case has to be remanded. No way can this case be dismissed without compliance with Title 28 U.S. Code Section 1441 through Section 1449. Case cannot be dismissed. Until you have the record from Nassau Supreme, you are not fully aware of the facts and circumstances. U.S. Code Section 1441 to 1449 must be strictly followed. They must be strictly construed. Removal statutes are strictly construed against removal. The removal statutes really are against removal. They should be, as an American document. Removal is an anachronism. It is an ancient, arrogant, anti-American anachronism and should be abandoned. Alliteration. Removal violates Glendora's Article 4, Section 4 constitutional right to a Republican form of government. It is Gestapo. Removing defendants, whoever they are cornered. We will watch with interest what they do now. We've got them. We've cornered them just now. Page 9. Defendants, whoever they are, did not prove Glendora was asking for more than $75,000. Defendants have burden of proving this amount. All of Glendora's claims can be adjudicated under civil rights, New York State Constitution. I don't need to be in federal court with this case. Civil rights cases cannot be removed. Black and white law. Civil rights cases cannot be removed, and this is a civil rights case. Defendants, whoever they are, concede that Glendora's complaint is well pleaded. Refer to Vairo, V-A-I-R-O, the author, in Moore's Federal Practice. Removal. Only cases in which federal questions appearing on fact of well-pleaded complaints are removable. In other words, you can't remove a case if the complaint is not well pleaded. So in removing this case, they concede Glendor's complaint is well pleaded. Here is a whole page on federal removal law about well-pleaded complaints. That is page 10, and we are taking a break. I'll come back and read you 10 pages more when I recover. Watch what Glendora says as she cites the law. Plaintiff generally is master of complaint. Plaintiff not required to assert federal claim. Effect of post-removal dismissal of federal claim. Watch it, Raji. Plaintiff is master of the complaint. Plaintiff is plaintiff's selection of her cause of action is controlling. It ends the removal inquiry. Defendants did not invoke Title 28 U.S. Code, Section 1331, the statute that deals with general federal question. Defendants attach no exhibits. All defendants must join in the removal. Title 28 U.S. Code, Section 1446B, Chicago versus Martin. 28 U.S. Code 245, 248. Generally, all defendants must join in the removal, and this is a statement of the law to Raji, the judge, and to whoever removed the defendants. And remember, not all defendants are removed, and they have to do that. The defendants failed on notice of removal should explain the absence of any defendant. And on this ground alone, says Glendora, the remand must be effected. Removing defendants have the burden of proving that the removal is proper. Removing defendants have not done that. The defendants have failed, taking from more legally removed from state court by the arrogance of the federal court, and that I am showing that the removal is fatally defective. It has to be remanded to state court. Party alleging federal jurisdiction bears the burden of proof. These defendants did not do that. Removing defendant must show compliance with removal procedure. 1, they didn't comply, and 2, they can't show it. The grounds to effect a remand. The district court must remand all claims barred by the 11th Amendment. Ha-ha! Defendants cannot argue res judicata, that this case has come before and it's been adjudicated. It has not been. discovery. No removal if both parties agree that defensive presumption is a sole issue. And Glendora did this. Act under color of office. Federal officer removal requires that the case involve acts committed by the officer under the color of office. Removal procedures and the effect of removal. Procedures for removal. Section 1446, procedure for removal. Well, whoever removed it did not sign, and it was just a scrawl, and scrutinize the notice of removal. Glendora, a chat with Glendora, Box 416, White Plains, New York, 10602, has never received a copy of the removal. We are up to page 17. I read 10 pages of this or so, and then I go help Franklin. We are scrubbing the dining room, and we have got rid of a lot of dirt. And now we're scrubbing the courts and trying to get rid of dirt. Documents required, a notice of removal, and the contents of the notice. And what is required by law for the contents of the notice has not been complied with by whoever these defendants are. Signature requirements. Notice of removal must be signed pursuant to Rule 11, Federal Rules of Civil Procedure. The papers, if they exist, must be supplied to the plaintiff, and that has never happened. And the verification requirement. Page 19. Remand must be ruled. There was no notice to other parties, let alone to the plaintiff, who is the master of the complaint. The notice to other parties and to state courts. No service list was filed. When a case involves multiple defendants, and this one does, about 35 or 40 of them, most courts hold that the 30-day removal period begins to run when the first defendant is served. My goodness, that was way back in November of 1998. Majority rule, 30-day removal period begins when the first defendant is served. Despite the superficial attractiveness of the minority approach, the belief view is the majority majority view. First, the removal statutes are strictly construed against removal. Now, there are no grounds, Glendora says, are given. Are there any such as federal question or diversity? Removal statutes are strictly construed against removal. We are now on page 21. Goldberger did not make the 30-day limit. You only have 30 days to file a removal, and he did not make that limit. And it will be very interesting to watch Raji try to rig this in favor of the feds. It'll be very interesting to watch her calisthenics. Removal is kaput. It is the law, and the law must be enforced. Page 22. This case was never initially removable again because it could not be filed in the Eastern District of New York, Brooklyn, because the record shows abundantly and dismally that Glendora cannot get justice in the Eastern District of New York. Remember Bruiser Ken? The Eastern District of New York must have before it the file of the Nassau State Court. The 30 days has expired long ago by like 2 years. 30-day limit is missed. Here again, this paper reproduces the law as discussed in Moore's Federal Practice, and the author of that discussion is V-A-I-R-O. See the state court file. And the 1-year limit is also over. Nickerson, even if all else were legal, is untimely. When this case was removed, it went to E.H. Nickerson. He did nothing on it. He did not do his job. He did not do his work. And then behind our backs, without any explanation, the case is assigned to Rina Raji. Page 25. Multiple defendants we do have. The law's violated case was not initially removable, says Glendora, and it cannot get justice in the evil Eastern District of New York. Page 26. The other defendants were not served, then the plaintiff was not served. At Glendora, A Chat with Glendora, Box 416, White Plains, New York. Page 27. They had their opportunity to say that the case was removable. They did not, and they didn't, and the file notice of removal in 30 days. The effect of lack of service on all defendants. Note, Glendora tells Raji. Now pages 39 and 29 and 30 are reserved. This is always a good idea to reserve. Add it later. And what is the name of this paper again? Shareholder Glendora Answer to Raji Order of February 6, 2001, United States District Court, Eastern District of New York. The date that it was started, it took 30 days to write this paper. I started it on February 12th, Abraham Lincoln Day. Shareholder Glendora Plaintiff versus Robert S. Lemley, and a whole other list of Cablevision lawbreakers, and TCI, and John Malone, and their liar for hire, and several judges, William Connor, Jed Rakoff, Mark D. Fox, and some judges in the Eastern District. Oh, Barbara Jones in the Southern District, Amalia Kurse in the Second Circuit, Jose Branis in the Second Circuit, Danny Chin, who is sitting in the Second Circuit but is really a district judge, Charles L. Bryant, Thomas A. Tormey, his fugitive clerk, U.S. West Telephone, who bought Hofstadter, Continental, Media One, Richard McCormick, Charles Lillis, Thomas E. Waltz II, their liar for hire, Azrak, Levy, Ramos, Brennan, and Bigger, all tortfeasors in the Eastern District of New York. We are up to page 31. We will go up to page 41, and then I'll go do a corner of the dining room, cleaning, scrubbing, and polishing, making it smell bright and clean. And Franklin is doing the vacuuming. He has to sit down to vacuum. 30-day limit was not met. It's a very, very important point here. The jury trial was demanded. Glendora wrote this on the complaint to the New York State Court, and she wrote it on every paper thereafter. And until this is scrupulously followed, removal is fatally defective, and Raji Court has no jurisdiction. Test of Title 28 U.S. Code, Section 1447, procedure after removal generally. Defendants, whoever they are, failed on that. The defects in this so-called removal are very, very clear. What constitutes defect in the removal procedure? Removal is a nullity, and again, constitutes a procedural defect. No jurisdiction. Remember, the case could not have been filed in the Eastern District of New York. The EDNY refuses its duty to give Glendora justice. And the amount that these people were sued for is $323 million. Abstention, this is what the United States District Court, Eastern District of New York should do as patriotic Americans. The Eastern District of New York bombed on federal courts' general obligations to exercise jurisdiction. Quackenbush versus Allstate. 35 page, abstention again is discussed, and hearing on a motion to remand. The burden of proof is on the defendant. Defendants, quote unquote, failed. It's an easy job for Glendora because these defendants did not comply with the removal law. Admissible evidence in general, when ruling on a motion to remand, the court looks to the plaintiff's complaint as it is stated at the time of removal, and the defendant's notice of removal, and Glendora did not receive, was never served a notice of removal. Exclusive grounds on which a court may remand a removal case. So Raji had best remove. Why do we want it removed? Because there's no justice in the evil Eastern District of New York. Note, defendant bears the burden of proving federal jurisdiction. Defendant bears the burden of proving all grounds necessary to support removal. A district court has relatively little discretion when deciding remand. Up to page 37. The denial of remand based on futility exceptions, that there's no point in remanding it to state court because it's going to be dismissed in state court. That's ridiculous. Theirs is a procedural defect. If remand is illegally denied, this would mean a Title 28 U.S. Code 372C1. That's a complaint against a United States District Judge for conduct prejudicial to the effective and expeditious administration of the business of the courts. So if she removes, we file a 372 against her. Remand of entire case or part of a case. It's frowned upon. You have to keep the case together. Note that costs and fees may be awarded to the party prevailing, and Glendora wants pro se fees. And I don't care whether they've never heard of them or not. Glendora is deserving of pro se fees. The removal is not in good faith. Glendora asked for $383 million. Please do not pay in pennies. And this is what happened. They removed improvidently and without jurisdiction. We are winding down this section, which shows that the removal is totally illegal and totally fails, and the case has to be remanded to state court. A couple of more pages of that, and so I might as well read it. Glendora moves for the same Rule 11 sanctions on Goldberger for improper removal, and also on Loretta Lynch. And it says, what basis for removal is procedural defect? The case can be appealed. Let me say again that this case can be appealed on the basis that the removal is totally defective. And Glendora says next to that, gotcha. of mandamus. This is a 52-page memorandum of law. What is their motive? Obviously, the motive is to get Glendora into the Eastern District of New York, where she will be cheated again out of justice. That is plainly their motive. Reviewable on appeal. If ever a case cried for public policy, it is this one. America bleeds. Orders granting remand and standard of review. That's, can you appeal an order not to remove? Excuse me, can you appeal an order not to remand? And we are thusly up to page 45. It took 7 hours and 53 minutes in 1998 to write this paper. The removal is police state. Glendora is guaranteed a republic by the Constitution, Article 4, Section 4. Remember that. 4-4. Thank you, Georgiana Vairo, V-A-I-R-O, the one who wrote the discussion on removal in Moore's federal practice. Wherefore, says Glendora, the plaintiff has given more than sufficient reason why her case should be out of the self-serving clutches of the United States District Court, Eastern District of New York, Brooklyn, and into the New York State Supreme Court, where she filed it. Not to remove would be a defense, or rather a defiance of justice and antithetical to the American spirit. Glendora should be awarded the cost of this answer, print paper, $300 per hour, and emotional wear and tear, dated White Plains, New York. March 5th, year 2000, Anno Domini. When I return, we will go to Part D, which is part of my answer to why this case cannot be dismissed, why it cannot be remanded, why it cannot be removed. The dining room is clean, it sparkles, and it just smells so fresh. And I took the 3 rugs in the hall out to the south porch, the side porch, and shook the dirt out of those, and the sun is shining. We haven't seen sunshine since Saturday, right? Sunday, Monday, Tuesday, no sunshine. We are up to Part D of this answer to the Raji order to try to dismiss my case, which would be an affront to America and an affront to the laws made by Congress. We, under penalty of perjury, Glendora tells the truth, the whole truth, and nothing but the truth, and always has, so help her God. But judges in the Eastern District of New York do not care about the truth. How do you know, Henny Penny? The nursery rhyme asks. I saw it with my eyes, I heard it with my ears, and a piece of it fell on my tail. Who are these judges? Azrak, Levy, Goh, Ross, Gershon, Nickerson, Sifton, Corman. Defendants never have told the truth. That is how they get fraudulent judgments. This is enough about the truth that judges do not care about. What are the facts about this case filed way back in 1998? Glendora has won all the relief she sought. E.H. Nickerson failed to rule on Glendora's motion in 60 days. This is New York State law. He's in New York State. He practices law by the New York Bar, and his award for losing his campaign for governor of New York is a judgeship in the Eastern District of New York. So, bound by New York State law, Nickerson failed to rule on Glendora's motion in 60 days, and here, folks, is that law. See PLR, Civil Practice Laws and Rules. The time for deciding a motion must be decided by the court within 60 days after it has been submitted. Couldn't be clearer. Ergo, Glendora has won all of the relief she sought. If defendants do not pay by March the 15th, Glendora will refile Glendora versus Lemley in another United States District Court. The notice of the default by CPLR 2219 was given Nickerson and all defendants when the same occurred. It is in the record. There are so many illegal maneuvers in this case. To wit, Glendora never received a notice of reassignment. Raji order of February 5th was the first Glendora knew. Glendora's case cannot be dismissed. Glendora Plaintiff Appellant versus Cablevision Systems Corporation, Charles F. Dolan, William J. Bell, Mark A. Lusgarten, Francis P. Randolph Jr., John Tata, James A. Colfault, Joseph Osnara, Thomas Garger, and William Quinn, defendants appellees. In the United States Court of Appeals for the Second Circuit, January 11, 1995, saying that Glendora appeals from the judgment of the United States District Court in the Southern District of New York, Charles L. Bryant, dismissing her complaint pursuant to Federal Rules of Civil Procedure 12b-6. For failure to state a claim upon which relief can be granted. However, says Van Grafelen, a circuit judge up in Rochester, in view of the well-settled rule, particularly applicable in pro se civil rights actions, that a complaint should not be dismissed unless it appears beyond a doubt that the plaintiff can prove no set of facts in support of her claim which would grant her relief. Branham versus Clark, Conley versus Gibbon, and we remand to the district court for further consideration. This is just the opposite of this one. I'm asking for it to be remanded to state court, this case, and the Cablevision case, which we won and made Cablevision put Glendora back on the TV. That was a case remand from the Second Circuit back to the district court. So that's the great victory, and it says very clearly that Glendora's case cannot be dismissed, so Raji cannot dismiss it. We're up to page 50. The removal violates practically every one of the 14 rules in 28 U.S. Code, section 1414 to 1449. To wit, a civil rights case cannot be removed. All defendants have to be removed, not just federal defendants. Cablevision defendants, Lemley, the lead defendant, never appeared. Callaghy and Satterley must be sanctioned by Rule 11, Federal Rules of Civil Procedure, as defendants trying to defend co-defendants. All of this is from memory. Glendora has not seen this case nor thought about it for years. It is deep in the Cablevision files of law-breaking of 24,400 pages. Glendora has personal knowledge that no good can come out of the United States District Court, Eastern District of New York. Said court has betrayed her, her husband, and the United States of America repetitively. She will file the case in another court where it cannot be illegally removed, as happened herein. The other illegalities in this case are clearly set forth in the clerk's file. The lethargy of Nickerson is unforgivable. His untimeliness is abysmal. It has thrown everything out of sync and distorted the perspective. Glendora versus Nickerson is about to be refiled. The Raji order, quote-unquote, defendants to dismiss this action is misleading. Only some defendants are involved. Most of them have not appeared. Glendora's motion for default judgment has to be granted. The court is ignoring the same, is not permissible. Who is Mark Goldberger? This is a non-entity. Check the file. It is Michael Goldberger. Glendora, why don't you trust United States District Judge Raji? You have never been before her. Glendora, because I trusted Levy, I trusted Azrak, Ross, Marilyn D. Goh, Nina Gershon, Corman, and Nickerson. And this was a mistake. Over and over and over again. The Eastern District of New York is dysfunctional. There is nobody in the EDY who does anything but betray. There is no justice in the Eastern District of New York, no honor, and no honesty. Nickerson is rankly in violation of Congress's cost and delay reduction order and of federal rules of civil procedure, Rule 1, just, speedy, and inexpensive. Glendora has personal knowledge that Michael Goldberg is hopelessly depraved, a bungler, a liar, and a cheat. He plays dirty. Page 53. All parties have not been served. Glendora's objections are all in the file. She hereby incorporates all of her statements herein as if fully stated herein. In other words, Glendora has won the relief she sought. McCormick has lost his company. He's one of the defendants. Lillis is out of his job. That's another defendant. Callaghy and Satterley no longer are Lemley's liar for hire. They've lost a lot of revenue since I've started suing them and excluded them from the lawsuits, or excluded them from defending Cablevision. Bruiser Ken has been canned 2 years ago. And what is the meaning of, quote, docketing this motion as having been served and filed, unquote, on February 6, 2001? This is a heterotaxis. Note, this is a verified answer. The court does not mention Glendora's motion for default judgment submitted Thanksgiving week, 1998. The Raji court has the wrong caption. The plaintiff is shareholder Glendora. Rhaegar Day, 60 Minutes last night, where a juror stated an innocent man had been convicted. A Nixon's case, Leumi Volpe. This is not the first time the Eastern District of New York has mistakenly convicted innocents. Franklin and Glendora were and are innocent and were convicted, quote unquote. The Eastern District of New York often fails, excuse me, its raison d'etre is to ascertain the truth, and it is no good at it. Glendora will file a Lemley case in another court where it cannot be illegally removed, as happened herein, and 37 is reserved. We are up to page 55. Malone lost his company, TCI. It was gobbled up by AT&T. Chomp, chomp, chomp. Malone put all his money in AT&T stock, which plummeted. McCormick lost his company, Media West. Media One went to AT&T, chomp, 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 chomp. He also lost his company, US West, to Quest. He also lost his job. Willis, of course, had even a worse end than McCormick. Magnus lost his life. Wiles lost his job. Koenig and Rapp lost their client, TCI. Brennan had to retire. No, it was Bigger. Bigger had to retire. And Thomas E. Walsh II lost his clients, Hofstadter, Continental, Media One, McCormick, Lillis, and US West. They are all out of business. Glendora has no notice as to whom Mark Goldberger represents. Add John P. Dunn to the service list. He is the so-called judge in the Nassau County Supreme Court where this case was filed and to which he was assigned. This case could not have been originally brought in the Eastern District of New York. The record pellucidly attests that Glendora cannot get justice in the Eastern District of New York. Glendora would never bring a case to the Eastern District of New York after she found out how bad it was and is. Why did Nickerson finally step down? Questions you have a right to know the answers to, but you never do. But you never get the answers. Page 57. Glendora did take time out of a Herculean schedule to go through 10 volumes of Cablevision files, a litany of law-breaking, and find the Lemley lawsuit. She is reading the complaint, an opus of observation and articulation. It is the well-pleaded complaint. Cablevision defendants are still breaking the laws of this land today as much as they were when Glendora filed the complaint in November 1998. This court must stop this law breaking. This court must enforce the law. Glendora has to be served properly. The motion to dismiss, she has not been served properly. She has not read any motion to dismiss. Page 57, Glendora has won all of the relief listed below. All that remains is for the court to force defendants to comply. And here is the prayer for relief that was in the original complaint. Wherefore, Glendora prays judgment be entered against all defendants, jointly and severally, a $323 million punitive and compensatory damages, injunctive and related relief, treble damages pursuant to 1964 C, the Criminal Code, 18 U.S. Code. Imposition and execution of equitable liens, the return of money unjustly collected, the reasonable restrictions on the future activities and investments of defendants, immediate discharge of defendants for their positions, for violation of their positions of trust that they have abused, an equitable accounting of all benefits, considerations, and profits received, any restrictions which may be appropriate on future conduct of or activities. The cost of this motion to Glendora for all other damages, relief, just and proper. Glendora hereby demands a trial dated White Plains, New York, February 17, 2001, twixt the birthdays of two great Americans whom the courts have betrayed. Yours in truth, Glendora. Page 60 is empty. Empty. And now, here we have a motion to remand or to transfer or to recuse. The movement is Glendora. The return date is March the 19th, 2001, Monday, after St. Patrick's Day. The location is 225 Cadman Plaza East, Peripatetic Courtroom of Rena Raji, U.S. District Judge. Relief requested is stated in the title. The legal bases are Title 28 U.S. Code 1441 to 1449, the removal law. United States, 28 U.S. Code, Section 1404, transfer has to be in the interest of justice. The case has to be transferred because the record shows Glendora has never got justice in the evil Eastern District of New York. Title 28 U.S. Code Sections 144 and 455, the senseless practice of the Southern District of New York and the Eastern District of New York of making judges out of assistant U.S. attorneys has to stop. Raji is a former U.S. attorney. It is not fair to the public. It is not a fair fight. The former AUSAs, assistant district attorneys, now U.S. district judges, are always going to rule in favor of their lineage. We have here Raji's a synopsis of her career. Who appointed her? Ronald Reagan. And a very old one, a very old synopsis. 6, the grounds are stated supra. 7, the supporting papers are Glendora's answer to Raji order of February 7th attached herein. 8, service of this notice of motion was made on all defendants, on the clerk, on the U.S. District Judge Raji, on Mark Goldberger by U.S. mail on March 5th, year 2001, Anno Domini, dated White Plains, New York, March 5th, 2001, yours in truth, Glendora. And here, folks, is the mailing list of the defendants, their addresses. And we're adding to the mailing list John P. Dunn, Supreme Court, County of Nassau, 1 Supreme Court Drive, Mineola, New York, 11501. And here is proof that Richard D. McCormick has lost everything sent to his address in U.S. West. It's forwarded. No forwarding address. Here's a whole pile of exhibits. And the chief of AT&T's cable TV operation quits. This shows you the gobbling up of TCI, Telecommunications Incorporated, by AT&T. And it shows you also how bad assistant U.S. attorneys are. This hero judge, James Parker, in New Mexico, said that the U.S. attorney really didn't have a case against Dr. Lee, the Chinese, the Oriental scientist. Accused scientist to be released on bail. Judge in secrets case rebuffs the prosecution. In other words, U.S. attorneys never know what the heck they're doing except lying, stealing, and cheating. And here's Cable King John C. Malone. The mighty fall with AT&T. A former cable king takes heavy losses. He put all of his money in one basket, and the basket's got holes in it. New York Times, FBI agent charged as a spy who aided Russia. And Glendora says, and Glendora and Franklin found out the FBI was no good, along with the U.S. Attorney Office, along with the Eastern District of New York magistrates and judges. 4 years ago, it's been 4 years ago since Bruiser Ken beat us up in the Uniondale courthouse, lied about it, and lied second time that we touched him, and we did not. When Bruiser Ken, Kenneth H. Mildworm, went into an insane rage and beat us up in a Uniondale courthouse, then lied he didn't and lied that we touched him. The case is now in the United States Supreme Court. Here's something else from the exhibits. An innocent man goes free 33 years after conviction. Again, they did it. Almost every day there's a story, almost every week in the New York Times, how an innocent person has been in jail for 25 years, 15 years, 30 years, this one 33 years. This is how rotten these people are at doing their job. The courthouse in the city sometimes sleeps. This is the Eastern District of New York, where one courtroom after another was empty. This is the envelope in which Raji sent Glendora the letter. They do have the designated address. Give her credit for that. This is her order that I have read you. This is my worksheet. The date that I put into this, and the total number of hours is outrageous, but from memory, I think it's 40 hours it took to write this paper. And it cost about $90 printing and postage. But it says, for instance, I'll read you an entry. February the 11th, Sunday, I was tied up with the Dolans, law breaking all day, and the make good is now 4:20 p.m. to 4:50 p.m. And then I tell what was done in that half hour. You know, these papers look insurmountable, but I'm telling you, there is a system. You keep a log, first of all, a worksheet of the hours and dollars you spent on it. And then you work on it a half an hour a day every day, and if you miss a day, you make it good. And eventually such a huge paper as this gets done. So this is the log. And the log itself is 6 pages. And this paper has been served. And you do it in the company of Bob Hope. Now, Glendora has made the Raji court these copies of what is in the state court a Herculean labor, time, and money. Under law, Raji court has to obtain the state court file, dated March 3rd, 2001, Anno Domini Glendora. So it started on Lincoln's birthday, February 12th. It was done on March the 3rd, which was a Saturday. Then came the storm and all the worry of how are we ever going to get this thing served timely. But we did, and it's over. And opus, what opus is it? 539. It's a great American document. We did it, Frankie. Okay, now let's sweep the hall, the bathroom, and the kitchen floors. And now, after that disgusting mess, we need some jokes, and the mess I refer to is the mess that the Eastern District of New York is making of Glendora versus Lemley et al. But I'm happy to report we scrubbed the kitchen. We just scrubbed it and scrubbed it and scrubbed it. And the Clorox and the Pine Sol make it smell so good. And then we did the hallway between the kitchen and the bathroom, and then we did the bathroom, and it's all clean. What are the goals? To keep the legal papers up to date. They are not up to date. To wash the 1980, and there's all this snow and ice. To wash the 1993, and to do the refiles. And the work up to date, and then to rest. And that hasn't happened in 2 or 3 years. All right, so jokes. A teacher will tell you that for every student who has a spark of genius, there are 10 more who have ignition problems. And one teacher retired after 30 years, and she said it was great in the early days. The kids used to bring you apples, and now they drive you bananas. And behind every successful man is a proud wife and a flabbergasted mother-in-law. And it's truly fitting that the senator won in all of the outlying districts, because during the campaign he was outlying in all of them. And Marilyn is not too bright. She thinks that Gatorade is what? Welfare for crocodiles. Paul says that his son is not too bright. He took a group of friends to the movies because the sign outside said 18 and under not admitted. He also saved up $45 for a rock concert because he heard that the tickets were $20 in advance and $25 at the door. Okay, next legal paper. We'll have time to start it, but I'm afraid we won't finish it in this edition. But that's all right. It never comes out right anyhow. So this legal paper was started on February 17th between the birthdays of George Washington and Abraham Lincoln. Where is the court? If you can call it that, it's the United States District Court, Southern District of New York. And these goons, McCasey and Griesa, haven't given it a case number yet. A jury trial is demanded. It's Glendora plaintiff versus the City of New York. It's Mayor Rudolph Giuliani. It's Parking Violations Bureau. It's Sheriff Teresa Mason. Peter San Marco, Assistant to Michael Phillips, Deputy Commissioner, Parking Violations Bureau, New York City, and Don Glow Auto Service Towing, defendants. This is the case where all of these defendants stole our property, the 1980 Lincoln. They took it without due process of law. They billed us $620 in parking tickets that they had never informed us that we had. And guess what this paper is? Oh, in this case, they returned all of the money except $20. They didn't pay for the damages, and they didn't pay the compensatory and punitive damages and for the cost of the litigation. And I sued these people in the United States District Court, Northern District of Alabama. 1, she shows cause. She cannot be fined $500 and cannot be robbed of her right to petition her government for redress in other U.S. district courts. And 2, wherein Glendora asks Mukasey and Griesa to show cause why they think filing a case in the Northern District of Alabama is the same as filing a case in the Southern District of New York. And show cause how an informer pauperous only on Social Security can be fined $500, and 3, wherein Glendora moves for relief from the order of February 7th, pursuant to Federal Rules of Civil Procedure, Rule 60B, and 4, wherein she moves Mukasey adjudicate Glendora versus the City of New York on its merits and give it a proper case number, and wherein she moves that if Mukasey and Griesa cannot do supra, they recuse immediately pursuant to Title 28 U.S. Code Sections 144 and 455. Part A. Glendora is appalled by the February 7th order, quote-unquote, of Mukasey, cloned by Griesa. It is dehumanized. The vehement and bitter denunciation raises questions that Thomas P. Griesa and Michael B. Mukasey are fit to discharge the duties of office of a United States District Judge by reason of mental stability. You know what this means. A complaint pursuant to 28 U.S. Code, Section 372C1. This report will be recorded by the Administrative Office of the United States District Courts. Correction.